rise. Court appeals to that session.
Please be seated. We are here in our case Wednesday, SA18096, HERNANDEZ versus the state. Each side will have 20 minutes to present their argument. Petitioner, you may reserve any portion of the time for rebuttal, but you'll have to keep track of the time yourself. We have a clock at the podium for you for that purpose. We are recording this argument. You'll be able to watch the argument again on YouTube, on our YouTube channel in a couple of days. Because we're recording it, please identify your client and yourself when you begin your argument so that we can keep everybody straight. We've read the pleadings and we've reviewed the record that has been presented to us. And we've conferenced the case, so we're familiar with the issues. Because this is a pretty discrete issue, you only take the amount of time that you think is necessary to present your argument and to answer our questions. Counsel, you may begin.
Good morning, Your Honors. May it please the Court, my name is Kyle Ewing. I represent the petitioner in this case, George Zodiac Hernandez. I would request to reserve 3 minutes for rebuttal. Your Honors, in this case, the state has conceded that they have access to this information that has been requested, the manuals and the testing. They conceded this fact through their response on page 11, paragraph 2, when they said that a court order provided to the publisher was enough to get these manuals.
So they currently have them?
No, Your Honor. To my knowledge, the state has made no efforts to get these manuals whatsoever.
Is your understanding of that if the court so ordered, the manufacturer would just have to give up its product for free?
I'm sorry, Your Honor. Could you?
I'm trying to understand how exactly they have access. I thought the issue was money.
That is an issue in this case, but that's not the issue in this case. The issue goes into the Rule 17 or Rule 15.2, where the Rule 15.2C governs what happens when experts are involved in cases. The requirements of the defense to disclose the information is the expert's name, their contact information, their credentials, and the results of the testing.
I understand that, but that's sort of a legal point. I'm just trying to clarify this factual point you made. The state concedes they have access to the materials in question. How do they have access?
They have access through their concession based on a court order. All they would have to do is ask the court to order the manufacturer to disclose the manuals to them.
Those are proprietary materials that have value. The court can't order a manufacturer to give counsel a car. Why would the court have the power to order that?
The court has the power to order that. I would say the court has the power to order that under Rule 15.2G.
But that's those are, Rule 15 is a discovery rule. I don't understand how that would give the court authority over a third party to order them to relinquish valuable property.
And that I should preface it by saying this, Your Honor. The first time that I heard that the publisher was willing to give these manuals up was in the response of the state. That was not communicated to me previously.
I thought your point all along was that the rules really don't contemplate disclosure of this type of material.
That's
They don't
correct.
compel it. It's just not on the table. So if it's not on the table for you, how could it be on the table for some third party?
The purpose of the rules of discovery are to make sure that either party is not surprised by an argument that is being made. It doesn't alleviate the responsibility of that party to investigate their own case. The whole purpose of 15.2G, which was the main reason this case was ordered, was because the state said they had a substantial need for this information. But in order to get there, we have to go through the steps of the state actually making an attempt to get it, a good faith attempt, and not being successful. That has not happened in this case.
I don't even understand why this is the primary issue. Isn't the issue whether, given the state of the record as it exists, whether the testimony is admissible under Rule 702?
That is the main issue, yes.
Not 802.
Correct.
I agree on that.
Correct.
So if the issue is really a Daubert one, rather than have a discovery battle over something that the rules don't contemplate, why not simply go to a Daubert hearing and test the experts' theories on the merits?
That was the main premise in the second part of my argument, Your Honor, is that the court did not follow the proper procedure in this case. If the court, or prior to the court precluding Dr. Walker from testifying, because he did not rely on the manuals, he doesn't have the manuals, the 702 hearing would be the necessary step prior to preclusion.
And no one is there yet.
I'm sorry, Your Honor, can you?
And no one is there yet.
No one is there yet, Your Honor. But Dr. Walker has been precluded by the court from testifying prior to the 702 hearing. And that really is the main crux of this argument, is that the state hasn't met the requirements under 15.2G. What we attempted to do at the hearing on April 10th was persuade the court that based on 15.2G2, this was an extreme burden on the defense. We were unable to get it, and based on the concessions of the state, they have just as much access to it as we do. The manuals.
Your contention that it's not even necessary.
That is also correct, Your Honor.
It may be a little beyond the scope of this discovery dispute, but I'm curious how you think your expert can withstand a modern 702 analysis without the material.
And Your Honor, based on that specific issue, Dr. Walker has been a licensed board-certified psychologist for the last 25 years. This is information that he uses on a regular basis. He's been on contract with the court for over 10 years doing these Rule 11 evaluations in which he does this testing.
So you're saying that he's so deep into this that his use of the test, or the knowledge of his use of the test, would qualify him as an author, so he doesn't need some third party's materials.
Correct.
But that's not an issue for us at the moment.
I don't believe that's an issue for you at the moment, Your Honor, because the 702 hearing has not happened. That would be the proper remedy in this case if the state wanted to dispute the defense's expert. But because that did not happen, that is one of the reasons that we're here. Under Rule 702, especially as far as involving the due process arguments, Rule 702, there are certain cases that discuss Rule 702. The main one that I cited in my briefings was the Amaya v. Ruiz case, where it talks about due process requirements in competency proceedings. That's why we're here at this point in time. We're not to the trial point yet. We are in a competency proceeding where we are trying to determine whether Mr. Hernandez is able to proceed to trial based on the issues that he has mentally. In the Amaya v. Ruiz case, it actually states that due process requires, and I quote, to to observe procedures adequate to protect the defendant's right not to be tried or convicted while incompetent. And I think the Wagner case goes in a little further into that point, which says that the conviction of an accused who is mentally incompetent is a violation of due process. And that is one reason why Dr. Walker's testimony is so necessary at this point in time, because we have a genuine issue as to the competency of Mr. Hernandez.
So that argument might go to whether we accept jurisdiction of the special action. Does it have any special bearing on the merits? I mean, other than saying it's an important issue, does it guide us in how to decide the case if we take it?
Based upon the case law dealing with this case, it definitely assists in determining how much emphasis the court needs to be giving on these experts' opinions.
Well, but if we had, let's say, I'm sure Dr. Walker is a fine expert, but hypothesize a series of really, really bad experts, really, really flimsy experts who had no business testifying under Rule 702, the due process concerns wouldn't alter the 702 analysis, right?
That is correct.
Okay. And from a discovery rules standpoint, the due process rules don't really alter that because you're just arguing that the rules don't cover these materials. So I'm just trying to figure out how due process plays into the merits, and that may sound counterintuitive, but due process is important. This issue seems to exist on a different level than due process.
And I would agree with you in part, Your Honor. I think due process is implicated at the point that Dr. Walker was precluded from testifying. That is where the due process argument arises.
Well, but what if this goes to a Daubert hearing and the court concludes that under Rule 702 his testimony is not admissible? Would that be a due process violation?
No, because the hearing was held. Because the court went through the proper procedures in doing that.
The only issue before us right now is whether the judge should have precluded the witness as a sanction for a discovery violation, correct?
That is partly correct, Your Honor, yes.
Partly correct?
Yes. The discovery violation is the main reason why Dr. Walker was precluded, according to the court's reasoning. But it also goes to the fact that the court did not go through the proper steps before the preclusion, which would be the 702 hearing.
But under the court's reasoning, there was no reason to proceed to a 702 hearing because the witness was gone as a sanction, so the court didn't even need to get into the merits of the testimony, right? So I think what Judge Howe is asking is the only issue before us whether that initial exclusion was correct or incorrect, and then that's really the only decision you have to special action, right?
That is correct. The main issue is the preclusion of Dr. Walker. That is where the due process violations occurred.
Right.
But going back, it relates to the order that was made in error, the 15.2 order.
But what we're here, at least as I understand the case, we're here to review is whether the judge was correct in precluding the witness as a sanction. If the judge was incorrect, then further proceedings, I assume, will happen below, because the judge's order will be reversed, and that's certainly not our concern, correct?
If I understand what you're meaning, Your Honor, that would be correct.
I don't see why it's a due process violation that the witness was stricken as a discovery sanction. Let's say that there had been some flagrant discovery abuse, not an arguable one as we have here, but just a complete call it a late disclosure, a false disclosure, just something very abusive under the discovery rules, couldn't the court strike the witness without violating due process?
In a case like that, Your Honor, I would say yes. Flagrant discovery issues, yes.
And then there'd be no need for a 702 hearing then.
I'm sorry, Your Honor.
Then there'd be no need for a 702 hearing.
That's correct. That's correct. The main issue here is that the judge based the decision to preclude Dr. Walker on the 15.2G violation, which...
We don't you may be right, but we don't really know what the judge based it on because the judge cited Rule 802, which I have a hard time fitting into this case.
I would agree with you, Your Honor, on that. The main reason for the orders, based on the case, if Your Honors will allow me to go into that, was the argument that a substantial need for the information was there, which was the 15.2G argument. That was the main reason that the court ordered the information. And the main crux of my briefings at the very beginning was that was made in error, and that was the cause, I apologize, that was the cause for the court precluding Dr. Walker from testifying. So, yes, a 702 hearing is the proper method if the state wants to contest Dr. Walker's ability to testify, but the court really precluded him.
Are you saying that the court's initial order under Rule 15, the disclosure order, are you saying that is before us as well?
It is, because that was what directly affected the preclusion. My understanding of
in terms of that you didn't file a special action from that initial order, though, is that correct?
That's correct.
In terms of the petition for special action that you filed, that is from the sanction.
That is correct. The sanction was when the issue became ripe for the special action. If it had happened before that, there hadn't been any harm to Mr. Hernandez prior to that point, because the defense was attempting to comply with the court's order. It was only after it became apparent that was very onerous in the 15.2G2 analysis that we attempted to go to the court and say, this is unreasonable, this is onerous on the defense, and at which point the court could have rescinded that order.
So is it fair to say that you are asking this court to accept jurisdiction and rule on both whether or not that was an appropriate sanction and whether the initial order was?
That is correct.
Correct?
And how can that be? You're only, as I understand, you're only petitioning from the sanction, but your petition is much broader than that.
The reason that we petitioned after the sanction was because that was when we believed the issue was ripe for a special action in front of Your Honors.
Are you saying that the petition challenges the enforcement, and if the order was valid, the petition must fail, and if the order was invalid, then the enforcement must fail? Is that
yes.
kind of the logic?
That is what we're saying.
Okay.
Your Honors, I see that I'm nearing the end of my time, so unless you have any other questions, I'll go ahead and sit down and reserve the rest of my time for rebuttal.
Thank you.
Thank you.
Good morning. My name is Julie Warzinski, and I am the respondent for the real party in interest, and I have to take the hit for the 802 stuff because during the argument, it was not set for an oral argument, it was set for a status conference. At the time, in a full courtroom with a full bunch of a bunch of people and a bunch of cases, and when it was my turn to argue, I think I just threw out the 802, not realizing it was 702. So
You meant 702?
I meant 702 and 703, and that was all on me. Defendant, I believe I just heard the petitioner concede that there was authority to issue a court order, because his argument was that the state could use a court order to get it from a third party,
Well,
which...
he's saying you concede that, and you're saying he concedes that, but I'm not sure if everybody in the room conceded that. I'm not sure that it's right.
I think the issue in this case is that the original order for the manuals was permissible. And it was permissible pursuant to the laws of evidence, the rules affecting discovery, and everything else.
Well, but I'm sorry, I've
Go
got to
ahead.
stop you because this does strike me as the crux. The rules of evidence do not authorize compelled discovery.
It does not. However, based on those rules, what the witness is going to have to testify is that they based the testimony on the product of reliable principles and methods. I am not contesting that the testing in and of itself is not reliable. I think it is very reliable. What the state is contesting is that the expert has reliably applied the principles and methods.
You're in a 702D world, and that's a fair point to raise. But isn't this the wrong time to raise it?
Well, kind of, yes. But kind of no, because in order for me to be able to cross-examine him on whether or not he applied the correct principles, I would have to know if he used them pursuant to the manual. And this has come up in many different cases that we have had. In one case, the manual was presented and it was used effectively to cross-examine a doctor who testified that the manual recommended hand scoring. By the issuance of the order to produce the manual, I was able to review that manual and cross-examine him and use it as an exhibit.
I'm sure it was great, and there are a lot of times that information that would be very helpful in cross-examination is not subject to mandatory disclosure. And I want to get to the Rule 15 arguments, but before we leave Rule 702, I don't understand why you can't cross-examine him on the current record. If he doesn't have the manual, then presumably he didn't use the manual, and you can ask him about that. And if he didn't use the manual, then you can ask him, well, how on earth can that be a reliable application of these principles which are written in the manual if you didn't use it? And then ultimately, I imagine he'll say, well, I've used this information so much, it's ingrained into my brain, and I don't need to refer to a manual. And then the court has a credibility determination to make.
And that is true. But the best evidence would be the manual to make sure he did follow the procedure.
Yes, but I mean, I'm sure the defense would often like all the information that the state has to help it in its cross-examination, but then we hear, well, Brady has its limits.
I agree with that. However, in the Rule 11 world, they are entitled to the material. The Restoration of Competency Program and the court's experts that do testing and rely on manuals are required to disclose that information. And they do routinely disclose that information.
If they have it.
I have never, in the time that I have been doing this, have a doctor that says he does not have the manual.
Well, and that's powerful cross-examination right there, isn't it?
It would be, but it's not the best.
Okay, so go ahead with your and then I want
Well, the onus, the state didn't pick the tests. The court's expert didn't pick the tests. The defense expert selected the specific tests he wanted to give. These are not normal tests given in every Rule 11. These are tests that he gives as a defense expert.
Okay, so that sounds like we just kind of had a little mini Daubert hearing, which I'm not sure, again, that we're at the proper juncture for that right now. So I would go back to first principles and then start with Rule 15 and see where in the rule do we get that sort of compelled disclosure.
Well, the rules state that you have to disclose the test results, and the testing material. That would include the manuals. So it's the testing results include
I'm now
by
seeing.
principle.
I'm not seeing the word manual in the rule.
It doesn't say manuals, but it's part of the testing protocol itself. So if you're disclosing the results,
Where it doesn't say protocol either, it just says the results of the test.
right? So the results of the test by principle would include how you got to those
Well,
results.
If what we have at issue is a drug test, right? The results are either positive or negative. Do those also imply an obligation to produce the operating manual for the machine, the service manual, any design patents? that slippery slope doesn't seem envisioned by the modest text of the rule.
And I would agree with that. And again, I am not contesting the reliability of the test itself. I am contesting, defense counsel has stated that the doctor did not rely on the test. Or the manual. That is clearly not the case because the results would be invalid if he didn't rely on the manual. He didn't review the manual, but he relied on what it had taught him at some point.
Again, though, I mean, I feel we're drifting back into Daubert land. I mean, it is, of course, incumbent upon the proponent of the evidence to lay foundation for it and to establish that it's admissible under the rule. I'm not suggesting that I have any views on that because this is an odd situation. But if we ask what is one side required to disclose under the rule, that's different than what is one side's best practices to disclose to avoid preclusion.
I would agree to the extent that it's not necessarily written word by word what is required. What is required is what the court needs to make its determination. And since the court is the arbiter of the competency decision, they are in the best position to know what is necessary for them to make that decision.
That sounds like a sound argument for a rule amendment. It doesn't sound like an argument for a rule interpretation.
We're stuck with the language of the rule, and I don't know how you squeeze the word manual into any of the language in 15.2.
Well, you
15.2C2.
You have both the Rule 11 rules, so you have 11.4B2 and you have 15.2. So when you're talking about the theory behind why the discovery is given, that would be encompassed by the raw data and the testing results. That is always included. This hasn't existed out of a vacuum, and while we have the rules, we also have certain cases that have come up where there have been litigations for this very purpose.
Rules trump cases. We follow. I mean, we follow the Constitution. We follow statutes. We follow rules, and we may follow cases as they interpret the Constitution, statutes, and rules. But that's what we're dealing with, not the cases.
Right, and it's the state's contention that not only is the actual pages of the raw data included, it encompasses the entire test.
So you want us to read the word results expansively then?
Yes.
And do we want to do that in every case from now on? Every case, let's start with the Rule 11 world. In every Rule 11 case, every expert now has to produce all of the technical background for every test.
The manual is yes, because that's what's being done. It's a routine discovery. This is one of the very few cases, and you will see the amount of time it took for them to say, we can't get it. The objection is not because they didn't have to disclose it, it was because they couldn't. So the first argument wasn't, well, you're not entitled to it. The first argument was it wasn't relied on. And when that did not work, it went to the next one, oh, it's too onerous.
Well, they may think it's not worth fighting about if they can give it, but if they don't have it and they're not entitled to give it, why can't they argue? We're not, if we had it, we'd give it to you, but we don't, and you're not entitled to it anyway. Isn't that the basis of the argument?
Well, but I think you're not entitled to it anyway because he didn't rely on it. I think there was an extra. Well, you're not entitled to it.
That's the case if this were to go to a Daubert hearing, right? Because you may say, I've relied on it, I memorized it, I lost my copy, I don't have it anymore, and I'm not going to go out and buy one for the state. The state can go out and buy one. that might be what he argues. He might argue, I didn't use it because, in fact, I think it's a little off. And in my vast experience, I've tweaked the methods and come up with a new method, and let me describe that for any of those are possible.
Any of those would be possible, but again, it would be incredibly difficult to show the court that he did not follow the proper protocol without the protocol.
But he hasn't been asked. If he says, yeah, I put the manual on my desk and went step by step, then I think he's got a serious credibility problem because he's already said he doesn't have it.
Right.
If he says, I didn't put the manual on my desk because it's not in my office or in my possession, then whole vistas of cross-examination opens.
It does, but let's say he instead says, of course I followed the protocol. I did X, Y, and Z. Okay. How can I say that that's not the proper protocol?
Well, I mean, I think, isn't that where you have your credibility issue?
Well, I have a credibility issue in that he hasn't provided the evidence for that, but if he gets up there and says, this is what I did.
We just keep returning, though, to the fundamental hearing that never happened, and I guess I'm still stuck on Rule 15. As I tried to encapsulate your colleague's argument, if the order to produce was valid and it was violated, then they don't have a case. They don't have on this special action. And if the order was not valid and preclusion was entered as a sanction for violation of an invalid order, it would seem they have a pretty good argument. Just as a matter of logic.
I agree with that.
Okay. So if then the order is valid, it has to be rooted in something other than the argument that you need the best cross-examination you can get, because that's nowhere embodied in any rule or case I've ever seen.
It's not just the best, it's kind of the only.
Well, I just gave you an alternative. I know that you don't prefer it, but it is available to you.
It is available, but in order to actually find out if he did it correctly, I would have to have the manual, and I am not entitled to get it. And I can't just issue an order. And with the time limits, Rule 11 is incredibly different than any other proceeding in this because of the time sensitivity.
You know, the civil rules of disclosure are much broader than the criminal rules, right? There's sort of this open file mentality that exceeds the disclosure under the criminal rules. But I'm still not aware of any rule or case or principle in the civil world that would allow a judge to say, go out and buy some stuff for the other side because they could really use it.
They're not buying it for me. They're buying it for the court and their presentation of their own evidence. And that's where the shifting of the responsibility comes from. What if it was the court's expert that did 30 different tests on the defendant, and the defense counsel would have to hire how many different experts to combat that? That is unfeasible in the Rule 11 frame due to the time limits. It's also untenable including you're just shifting the expense to the other party. So I'm going to use this test that costs millions of dollars, and I'm just going to do this because I know that they're not going to be able to afford it, and I'm not going to provide them any information about it. I think it goes both ways, which is...
A motion in limine rather than a motion for discovery sanction.
Which is, well, but in terms of what is expected of the experts in a Rule 11 proceeding...
Culturally or legally?
Both.
Okay, let's set culture to one side for a moment and talk about what's in the book.
Okay.
Because if we're missing some phrase or word in the rules that should support the validity of this order, I hate to do that walking out of here today, to educate us if we're missing something.
Well, and we've talked about that. I'm using an expansive use of the test results, and including in that the requirement that they provide the basis for the test results.
And I'm exposing my practical ignorance, so forgive me. Why can't the state purchase the manual?
Because they're protected. which is why we use protective orders and which is why we use court orders. The doctor, psychologist is not allowed to produce it without a court order and a protective order. I have manuals that I have received in other cases that I can only use for that case. I am not allowed to review it for this case. I am not allowed to use it for this case because it's a protected.
I always thought science was supposed to be this open community. How are the publishers achieving this secret?
They won't sell it unless you're a licensed psychologist and the psychologist's ethics, the canon of ethics, preclude them from disclosing without a protective order and or a court order. So we need to get the court order first, then we need to get the protective order, then we're not allowed to use it for anything else. Psychologists have a very strong hold on what they do. We have had doctors that have refused to turn over the results of the testing that have been precluded.
Doesn't really affect our Rule 15 analysis, but I would suggest that approach to science is an interesting comment on its credibility.
The state shares those feelings. However, if you look at the meaning behind the rules, the more expansive test results, I do believe, include it.
So you're saying that the word results is ambiguous?
I'm saying it can be expanded, which is what the court has looked at it and used an expanded definition.
The results means more than results.
The results mean more than just the number, because the number is meaningless without the other information. If you could look at a number, if you could look at a drug screen and it says positive, that gives you some information, or it gives you what the positive number is, that gives you some information. If you look at he scored a 6, what does that mean?
It gives you no information unless you know the methodology, because if I used my Mr. Science home drug test to get that result, that number 6 might be meaningless compared to a reliable test, right? And I think if that's where at the Daubert stage, at the motion in limine stage, at trial, should the Mr. Science kit get into evidence, that's where you tear that down. But I don't know that translates into discovery because the rules weren't written that way.
And that's where we would have our disagreement. I think the rules are more expansive than just the mere number.
And perhaps they should be.
Thank you.
Thank you, Your Honors. Just briefly, I wanted to respond to a few things that the state indicated. First of all, going back to the first thing that we discussed, is the state has access to this information through a court order, which the court has no issue making, as evidenced by the order that they already issued.
Would you oppose such an order?
No, I would not oppose an order being sent to the manufacturer to get this information.
And what's the court's authority to order a third party to disclose proprietary information that has ethical restraints placed upon it?
And I think that is something that the state cleared up for us, is the fact that in the response they said that the company is willing to do this. It's not about whether the court has to order it.
You said that they were not.
In the response on page 11, it actually says the company is willing to do this.
I know that's how you read the response, but it sounds like the state is saying that these are like the nuclear launch codes, and they're not giving them out no matter what. And they would probably expect a motion for protective order if the court issued such an order. All that is down the road and not really our concern in this special action. But I don't think it's as easy as just saying the court can order production of anything it chooses to.
I would agree that it's not as easy as it sounds. But I think that one of the main things that I wanted to respond to was the argument of what encompasses 15.2. In the Panzerea case, where this Court of Appeals decided how far that rule of disclosure extends, they actually state that it does not extend to the materials that the expert relied on. That the state has an independent obligation to do their own investigation on a case. And in cases like this, where there is an adequate remedy, whether it be through cross-examination, Dr. Willett Walker has been willing this entire time to be interviewed by the state, to give the state the information that they need, before we even got to this point where manuals that he neither relied on nor has in his possession is really an issue. He's willing to meet with the state. He's willing to lay it all out, for lack of a better word, to make sure that the state knows exactly where he got this information from. The order, because the state has access to this information, the same access that the defense has, the Rule 15.G order would be invalid because the defense has to have better access.
Does the validity of the Rule 15 order really turn on the state's access, or does it turn on whether or not that order or that rule requires disclosure? I'm not sure the access issue is your best place to focus here.
The Rule 15.2G actually states that they need to have, the party has to have better access to it, and the requesting party has to make a good faith effort to get it.
But it doesn't presume that it's something that is required to be disclosed under the rules, and I take your argument to be that it's not.
That is correct. In a case like this, because there is no substantial need, there is no requirement for it to be disclosed.
Well, but I read the rule, and you can read the rule as not encompassing that. See, whether they need it or not, so it's not encompassed by it.
And Your Honor, I apologize. I know I'm coming close to my time. I would like to answer that question with your permission. So, if I'm understanding your question correctly, you're wondering whether the rule encompasses the disclosure of the manuals. Is that correct?
As I understand your argument, is that this need not be disclosed because it's not encompassed within 15.2C2. The fact that they may have access to it or may not seems beside the point to me. Because the first question is, are they entitled to it or not? And I took your argument to be they're not.
That is correct.
So whether they have access to it or not really doesn't matter then.
Yes, that's correct. Thank you, Your Honors.
Thank you. Thank you for your argument today. We appreciate the help. We'll take this matter under advisement and issue a decision in due course. We stand adjourned.
Thank you.